We rest.
Okay, Mr. Coleman, you have the right to open and conclude.
The arguments on these cases are all essentially the same, ladies and gentlemen of the board. The only thing that I'll add to it on this particular case, and it is not necessarily unique to Mr. Kellogg's case. I could have made this argument on any of these we've been through thus far, except that we got new testimony today that supports it. This, in order for seems to be one of the chief arguments that they're going to put forth here is that policy wasn't followed 100%. We even got today into a number, 75%. I don't know how much weight that has, but as a general proposition of law, a policy, a deviation from a policy alone, even if a board policy or the policy of a city or whatever government entity, deviation alone doesn't show that there's any kind of discrimination or illegal conduct. In order to show that, the person making the claim has got to show that the deviation gave them a disadvantage or an unfair, or gave someone else an unfair advantage. And he hasn't been able to show that, and neither can any of these other people, because what we heard her say today was that she went and looked, and there's no evaluation there to look at. And the whole deal, it doesn't say she's got to go and consider a personnel file. It says she's got to go and consider written evaluations. So she would have to know where to look for those written evaluations since they're not in the personnel file. She testified that she didn't know where they were and that the proper place for them was the personnel file. If they're not there, they wouldn't have been there for her to consider, and therefore she would have had to rely on her personal knowledge and observation, just like she's told you over and over that that's what she's done. So the failure to review the personnel file, whether the policy actually says she's got to do that or not, which, I mean, I think is up in the air, and there's an argument both ways. But let's assume that it says that she's supposed to review the personnel file. If she'd gone there, she wouldn't have found any evaluations, and so there would have had no negative effect on Mr. Kellogg or anybody else. And that's all I've got to add today, or this morning.
Mr. Stoll?
My arguments are pretty much the same as I've made through most of yesterday. What's different about Mr. Kellogg's case is now the tacit admission that 25% of the policy or procedure wasn't followed. When you have a superintendent, if it's her duty to go to a personnel file and consider the evaluations in it, I don't think it's good enough as a matter of common sense to say, well, I went to the personnel file and this employee mysteriously had no evaluations in it, so I don't have a duty to go further and find his evaluations and look somewhere else for them, perhaps in the principal's office or somewhere else. I think it's real folly to believe that not only in Mr. Kellogg's case, but in at least one or two of the cases yesterday, no one can find evaluations. That's a red flag for the fact that if you know they were done, they're somewhere, it's incumbent upon the school superintendent to find evaluations and consider them, no matter what she has to do. One of the things she could have done, had she chosen to do so, I would argue, is when you go to a personnel file and you know a person's been evaluated, because they're required to be evaluated, at least at some point, and you see that there's no evaluation there, there's nothing that stops the superintendent, if she had chosen to do so, in calling up Mr. Kellogg or anybody else and saying, did you get an evaluation last year? Yes. Do you have a copy of it? Yes. I had no problem having Mr. Kellogg produce 2 or 3 of the documents which are now in the record of this case, and they were indeed evaluations of him. So the information is out there, you know, if one chooses to look and get it. And that was not done. That's one thing I want to bring up. I already made age arguments yesterday. I believe doing all over 40 is patently illegal under federal law. The third thing is I don't believe policy was followed. It was enacted to be followed. It wasn't enacted because y'all had nothing to do other than come up with a policy and procedure for RIF. And then fourth, you've heard what we call, as lawyers call, unrebutted testimony from Mr. Cook in this case, that personnel matters were discussed before these hearings even began, and individual names and who would be gone and who wouldn't be gone. Unrebutted testimony simply means that one side, such as we did, asked Mr. Cook questions, that evidence is out there, and the other side, if you will, Mr. Coleman, doesn't rebut it, meaning he doesn't come forward with evidence himself to contradict or counteract the evidence that Mr. Cook made. Now, not only did he not bring in a witness to say Mr. Cook doesn't know what he's talking about, he didn't choose to cross-examine Mr. Cook, so you've got to accept what Mr. Cook said as being the case. For any of these reasons, for all the reasons, to discharge Mr. Kellogg under these circumstances, I submit, is wrong, it's unfair, it's morally wrong, but most significantly, because I'm a lawyer, it's legally wrong. I would ask you not to do so. Thank you.
Mr. Coleman, conclude.
Nothing concluded.
Thank you. Mr. Chairman, matters with you.
I'd have a motion to go into executive session.
I make a motion to executive session.
Second.
I second.
Go into executive session. All excuses for a period of time, please.
You're going to have to confirm that, yes, sir.
I'm sorry.
You have to take a vote.
Second.